I thank the honourable member for her point of order and for confirming that she has notified the member for Runcorn and Helsby in advance. Mr Speaker has always been clear that members intending to visit another colleague's constituency, except for purely private purposes, must inform colleagues in advance. Point of order, Simon Hoare.
The Honourable Lady for Brent East is absolutely right to draw the House's attention to the Nolan principles of public life, and they fall within the auspices of my select committee to keep a weather eye on, and of course it's an important anniversary of the Nolan principles this year. Given the fact that it is an important anniversary, and given the fact that the government has pulled together a whole variety of propriety and ethics under one body, might it now not be appropriate for the authorities of this place to reissue to all members what those principles are, that they are as enduring and relevant today as they were when Lord Nolan first penned them, and if we all abided by them fully all of the time, political and public life may be a little better.
I thank the honourable member for his point of order. It's a very interesting idea. They are set out in the Code of Conduct, but I'll make sure that Mr Speaker is aware of his comments. I have to notify the House, in accordance with the Royal Assent Act 1967, that the King has signified his royal assent to the following acts. Bus Services Act 2025, deprivation of citizenship orders, effect during appeal Act 2025, Renters' Rights Act 2025, absent voting, elections in Scotland and Wales Act 2025, General Cemetery Act 2025. We now move on to the business of the day. The clerk will now proceed to read the orders of the day.
Victims and Courts Bill as amended in the Public Bill Committee to be considered.
Now.
We will begin with Government New Clause 13, with which it will be convenient to consider the other selected new clauses and amendments as listed on the selection paper. I call the Minister to move Government New Clause 13. Minister.
Thank you, Madam Deputy Speaker. It is truly an honour to open this debate and to bring the Victims and Courts Bill before the House. This bill is about people. Victims who have suffered unimaginable trauma, their families, and ensuring that they receive justice. It is about restoring faith in our justice system that can often feel cold and confusing. And this delivers on this government's driving mission for safer streets, making sure victims are supported, that offenders are held to account, and that justice is delivered swiftly and fairly. The deep-rooted issues in our criminal justice system need no repeating here. The House knows that this is a system that requires large-scale reform after years of neglect. There is a long road ahead, but this bill takes an important step forward. At its core are victims' experiences. This government is bringing forward real, tangible measures to ensure that victims' voices are heard, that their needs are recognised, and that their rights are respected. This will strengthen our courts, improving efficiency and fairness across the system. Madam Deputy Speaker, these are much-needed changes, and I am deeply grateful to honourable and right honourable members on all sides of this House for their time, their insight in considering them, and indeed to all of the organisations, advocates and survivors who have shared their experiences and helped us shape this legislation. I am sure the House will therefore join me in paying tribute to the families of Jan Mustafa, Olivia Pratt-Cobell, Zara Alina and Sabina Nessa. And I would like to welcome to this place Aisha Hussein, Cheryl Corbell and Antonia Elverson. They are in the public gallery today. I would also like to thank Jabina Islam, Farah Naz, the Justice for Victims group, which includes Susan and Jeremy Everard, Glenn and Becky Eunice, Katie Brett, Paula Hudgell, Aisha Hussein, the Bethan family, all for their courage and strength in campaigning amongst immense grief for their loved ones. 3 government amendments at report stage have further strengthened this bill, delivering clearer, stronger protection for victims, and I will turn to these briefly now, and again thank you all to everyone who has worked so constructively with me and officials in the Ministry of Justice to discuss the issues and concerns. New Clause 14 and Amendments 12 to 21 restrict the exercise of parental responsibility for perpetrators of rape where their crime has resulted in the birth of a child. This amendment will of course protect children, but it will also help shield the victim from their perpetrator interfering in their lives. Because those who commit this horrific crime should clearly never be able to use parental rights to control or torment their victim. I would like to take a moment to pay tribute to a woman I am proud to call my colleague and even prouder to call my friend. Many in this House will already have deep admiration for the member for Bolsover. And I want to place on record that this change is hers. It is for her, her children, and those just like them up and down the country that she has dedicated her life to fighting tirelessly for. Yeah.
I thank the Minister for giving way. I want to add my personal admiration to the member for Bolsover, who has been a fantastic champion for this particular new clause. Her predecessor in this House was called the Beast of Bolsover. I think she's the Brave of Bolsover, because every time she speaks in this House, she's incredibly brave, and I want to pay tribute to her.
Hear, hear, I echo those sentiments entirely. It has genuinely been my privilege to hear her story and to work with her to ensure that this measure works to stop rapists taking an active role in a child's life when that child was conceived as a result of rape. I cannot imagine the enormous complexity that mothers such as her face in this situation, and I am in awe of her bravery and that of so many others. This measure will ensure that rapists cannot take active steps in a child's life where that child has been conceived as a result of the crime that they have been convicted for. And in order to protect as many children as possible, our measure features a two-track process. Where the Crown Court is satisfied that the child was conceived of rape, it must make a prohibited steps order restricting the offender's parental responsibility unless it is not in the interests of justice to do so. We recognise that rape can occur within an abusive relationship, and this may make it difficult to prove at a criminal trial that it actually led to the child's conception. Where this is the case, but the court considers the rape may have led to the conception of the child, it will refer the matter to the family court via the local authority. This two-track process sends a clear message that we will protect all children born of rape, no matter the circumstances. The Government recognises the clear risk that serious child sex offenders pose to their children, and that is why we have brought forward Amendment 10, which will expand Clause 3 of the bill. It means that when someone is sentenced to 4 or more years for serious child sexual abuse against any child, the courts will automatically restrict their parental responsibility. The process will remain the same. At the point an offender is sentenced, the Crown Court will be required to make a prohibited steps order restricting the offender's exercise of parental responsibility for all the children for whom they hold. For an offender to be in scope of this measure, they will have to have demonstrated that they are unable to protect children and consider their welfare. That is why our measure includes all serious child sexual abuse offences against all child. And unlike the previous government's plans in the Criminal Justice Bill, this is not just limited to the offence of child rape. What is more, unlike the previous government, this government will actually deliver it. We are taking this important step today to protect even more children by preventing these individuals from taking active steps in their children's lives. We have recognised the strength of feeling on this issue, and I am grateful to my friends, the members, especially, as already mentioned, my honourable friend, the members for Bolsover, but also to my honourable friend, the member for Lowestoft, the member for Dwyfor Meirionydd, and Baroness Harman in the other place. They have been unwavering in their advocacy for the protection of children. Safeguarding children is of the utmost importance to this government, and this amendment ensures that we are doing just that. I will happily give way to my honourable friend.
She just mentioned some pioneering women in this place who've campaigned on this very issue for a number of years. But today's amendment stands on the shoulders of the brave victims and survivors who've spoken out over so long as well. This corrects a historic injustice whereby convicted sex offenders and paedophiles children are protected from them, but before now their own children are not, and this government is now taking steps to make sure children who are through no fault of their own and their parents are protected from these vile sex offenders.
My right honourable friend is right. This bill is a testament to the victims and survivors, those brave victims and survivors who have spoken out about this injustice, and it is this government that is correcting that. My right honourable friend also talks about standing on the shoulders of brave, brilliant women in this place who have come before us and are still here. And it is quite apt now that I would also like to pay tribute to her, because new clause 13 concerning the misuse of non-disclosure agreements known as NDAs is a testament to her brilliant campaigning on this work. The government is very clear that NDAs must not be used to silence victims or witnesses of crime. Victims must be free to tell their truth, to seek help and to warn others. New clause 13 will void NDAs to the extent that they seek to prevent a victim or a direct witness from speaking about criminal conduct to anyone and for any purpose. It will also protect disclosures about how the other party responded to the conduct or allegation, so that victims are not prevented from sharing that full context of their experience. This measure builds on the Employment Rights Bill, which addresses the use of NDAs in cases of workplace harassment and discrimination. The measure will bind the Crown, but it will not apply to a very narrow cohort of specified agreements for national security reasons. It includes regulation-making powers to define accepted NDAs, where both parties genuinely wish to retain confidentiality and to ensure that certain disclosures will always be permitted. Once commenced, this measure will replace Section 17 of the Victims and Prisoners Act 2024, which allows limited disclosures to certain bodies. Together with the Employment Rights Bill, we are taking the necessary steps to ensure that NDAs cannot be misused to silence victims or obstruct justice. I'd now, Madam Deputy Speaker, like to briefly address a number of other concerns that have been raised and tabled as amendments. I will not preempt what will be said today in the debate, and I will give honourable and right honourable members the time to make their cases. However, I again thank those on all sides of the House for engaging with me and setting out their concerns. Turning to the amendment tabled by my honourable friend for Bristol East, which seeks to place a statutory duty on the Crown Court and HMCTS to determine whether an offender has parental responsibility for a child following sentencing. The amendment is very well intentioned, but it does risk creating practical difficulties. Determining whether a person holds parental responsibility, has dependent children or children living in their household may require interpretation of family court orders, birth records or informal caregiving arrangements. These are matters for the family court. Imposing such a duty on the Crown Court risks delaying sentencing. This government made a manifesto commitment to identify and provide support for children affected by parental imprisonment, and the Ministry of Justice and Department for Education are committed to working together to determine the best way forward to do this and deliver on that commitment, to make sure that every child gets the support that they need. The Right Honourable Member for Newark and the Honourable Member for Chichester have tabled amendments to remove the 4-year custodial threshold that applies to Clause 3 and to expand the number of cases where Clause 3 will apply. I want to be clear. This measure is not simply about when parental responsibility should be restricted. It is about when that restriction should happen automatically. We need to be mindful that this is a very novel measure. Removing the threshold would add a very large number of cases to what is an untested approach. More cases will also mean more applications to the family court, and it is important that we do not overwhelm the court and create delays which will put the vulnerable children already in the system at further risk. We want to be sure that there are no adverse consequences for those children and their families already in the family court, and that is why we have struck to keep this measure narrow, so we can understand exactly how it is working in practice and what those impacts are. As I said at second reading and through the passage of this bill committee, this is just the beginning. As part of implementing these measures, we will seek to understand how they operate in practice and ensure that there are clear routes through the family court for the parental responsibility of any perpetrator who does not fall into this measure to be restricted. The Right Honourable Member for Newark has also tabled amendments on the unduly lenient sentencing scheme. Parliament intended the ULS scheme to be an exceptional power, and I recognise the importance of finality in sentencing to avoid ongoing uncertainty for victims, those convicted, and society more broadly about the sentence to be served. However, I do recognise the exceptionally difficult circumstances for victims and their families in making a referral to the Attorney-General within the 28-day limit. The Law Commission is carrying out a review of criminal appeals and held a public consultation which sought views from a range of different individuals and reforms to the ULS scheme. It did include extending the time limit and offences in scope. The Government will, of course, carefully consider the review's final recommendations. However, Today, I want to assure members from across the House that I have heard the strength of feeling on the unduly lenient sentencing scheme. The amendments have been tabled on this matter raise very important issues, and I will be continuing to look at this carefully as it progresses to the other place. On that, I make a commitment. The Honourable Member for Newark has also tabled an amendment on victim personal statements, a topic on which I must also pay tribute to my honourable friend, the Member for the Forest of Dean, for his dedicated campaigning on. Victim personal statements can be an incredibly powerful way for victims and their families to tell the court how the crime has impacted them, and for the court to directly hear evidence about the harm caused when considering its sentencing of the offender. This is the victim's voice in the courtroom. It is important to understand that these statements are evidence submitted to the court to assist the court in determining sentences. As evidence, they are subject to strict rules which the court applies to ensure that the criminal justice process works fairly and effectively, and that is why the content is limited to explaining the impact of this crime. However, I will happily give way.
I thank the Minister for giving way. It takes me back to a family and the father of young Violet Grace, who was killed in 2017, 4 years old, 80 miles an hour in a 30-mile zone, and the people involved went missing. And during the course